Good afternoon, everyone. My name is Mugdha Lele, and on behalf of the TechX team at Venture Center, I am happy to host the third wave of our Only One Theme Awareness Talk series on innovation management. I welcome you to the sixth talk in this wave of Only One Theme. Today's topic discusses non-disclosure agreements and material transfer agreements, and our speakers for today are Archana Joshi and Mamatha Rangaswamy. Let me briefly introduce both our speakers before we begin. Archana is an experienced intellectual property rights professional serving as a registered patent agent at the Indian Patent Office and a registered trademark agent at the Indian Trademark Office. With a master's degree in organic chemistry from the University of Pune and a postgraduate diploma in patents law from Nalsar University, she has over 10 years of experience in drafting, filing, and prosecuting patents, trademarks, industrial designs, and copyrights. Archana has also been awarded by 57 RTTP CE credits for technology transfer and commercialization. She regularly speaks at IPR workshops and has a vast experience in drafting, negotiating, and vetting various commercial agreements for startups, SMEs, and educational institutions. Welcome, Archana, to the session. Our other speaker is Mamatha Rangaswamy. Mamatha is a senior patent associate at Venture Center, specializing in intellectual property with a focus on patents in the life sciences and biotechnology domains. She also has a postgraduate diploma in Patinformatics from CSIR-URDIP, Pune, and she holds an M.Sc in Botany with a gold medal at an M.Phil in seed technology and a Ph.D. in Forest Biotechnology from Forestry Research Institute University. With extensive research experience at CSRTI Mysore and as a research scientist at CSIR-NCL Pune, Mamatha brings expertise in patent preparation, prosecution, patent searching, and drafting. Welcome, Mamatha, to the session. So, with this brief introduction about Archana and Mamatha, handing over the session to them.
Thank you. Thank you, Mugdha, for the introduction.
Thank you, Mugdha.
Yeah. So let us start. Just please allow me to share my screen. Just a second. Is it visible?
Yes.
Yeah, thank you. Good evening, everyone. So I am Archana Joshi. I am a part of TechX team. So I will be talking about this NDA and MTA first, the structure, the elements of MTA, etc. And Mamatha will be talking about the case study, the specific case study, and she will also show you the specific agreement related to the material transfer. So let us start the session. Yes, so as I have mentioned, so I will cover what is NDA when it is needed, the elements of NDA as well as MTA and the best practices. What is NDA? So NDA is a non-disclosure agreement as the long form per se. It is also called as confidentiality disclosure agreement, proprietary information agreement, or secrecy agreement as well. But the agreement comprises the similar clauses. However, the names are different. As I have mentioned, proprietary information like PIA, confidentiality disclosure agreement, CDA, or secrecy agreement. Basically, it is a legal contract between two or more parties. The multiple parties can be there in this particular agreement. And why do you need this particular agreement, CDA or NDA? Because the parties agree to share the confidential information specified in the agreement. So basically, this is related to the confidential information. Hence, it is called as confidentiality disclosure agreement as well. It is to restrict the use of confidential information from generalized use or disclosure. So the parties of this particular agreement agree on certain terms and conditions, and with those certain terms and conditions, the particular confidential information shall be used. It should be signed prior to exchanging the information. Once you exchange the information in any form, like oral, written, visual, in any form, it will not be of any use. So prior to exchanging the information in any form, it is always advisable to sign the non-disclosure agreement or confidentiality disclosure agreement first. Yes, I have covered this point. Like sometimes it is also called as proprietary information agreement, confidentiality disclosure agreement, or secrecy agreement. It can be one way or two way. Only one party is sharing the confidential information with the other party, or multiple parties, or the two parties who are signatory to this NDA, both of them are sharing the confidential information. Based on that, the type of NDA is defined, whether it is one way or two way. So when do you need this NDA? So I have mentioned certain scenarios over here. So when a startup wishes to disclose the confidential subject matter with the investor, if a startup is seeking any investment in his company, in that case, he needs to disclose the confidential information, which is very, very important, which is also a proprietary information. It can be the technical or financial information as well, which has the commercial value. And when it comes into the public domain, it will be harmful to a particular startup. So in that cases, the startup should sign the NDA before disclosing the confidential information with the investors. So second scenario is when the inventor wishes to get the sponsor for developing the research work through industrial partner. If any industrial partner is there, and if the inventor is looking for an industrial partner for the development of his technology further, getting it to the higher TRL level of this technology, in that case, he may wish to sign the NDA because he will be disclosing the very, very confidential information with the industrial partner. So in that cases also, it is also advisable to sign NDA first. Between the two parties in order to evaluate potential business relationship. Yes, suppose if two companies are there and if they want to explore the potential business relationships, for example, the mergers and acquisitions as well, I have mentioned, or the joint ventures. So in that case, in order to start the discussion, you should first sign the NDA. Then to participate in preliminary discussions with potential licensee, if you want to license your technology or a patent with a third party, in that case, it is always advisable to start your discussion with NDA. And then you can, based on your negotiation, you can sign the license agreement for that particular technology. Another thing is that you need to ensure, so in case of employment contract, you need to ensure your employees cannot share your organization sensitive data while on the job or once they leave. So for the employment contract as well, you should define certain clauses of this NDA, or you can sign a separate NDA with your employees. In case of mergers and acquisitions, when you are selling your business sensitive financial information or any operations related information, it should be shared not just with the entities that who is buying your business, but you need to share this information with the intermediate as well, for example, the brokers. So in that case, NDA ensures the data is protected and it is not leaked, it will not go into the public domain. And the last thing is, when do you need NDA? That when you are contracting with the vendors for any type of services, you may need to disclose your information to your vendors as well. So in that case, you can sign this non-disclosure agreement. Then what is the confidential information? As we have seen, non-disclosure agreement is signed with respect to the confidential information when one party or both the parties are sharing their confidential information with each other. So what is this confidential information is? So this is the information that is not publicly available, that is not available in the public domain in any form. That is called as a confidential information. It should be valuable for enterprises or the inventor. It should have some commercial value, and it should be kept as a secret by the owner. Then examples of confidential information is, it can be any data, chemical structures, formulae, drawings, manufacturing processes, idea or invention yet to be disclosed to the public, unpublished patent applications, software code, algorithms, financial information, business plans, client list. It can be anything, any kind of information which has a commercial value and which is valuable for the enterprises or the inventor. That is called as a confidential information. Then what are the advantages of signing this non-disclosure agreement? So this is a confidential clause in the non-disclosure agreement which defines the confidential matter for which the non-disclosure agreement is signed. So there is an agreement which will defines the roles and responsibilities of the recipient as well as the provider, especially related to the recipient. So recipient is who gains the confidential information from the provider who has the ownership of that particular confidential information. So these are basically two parties in the non-disclosure agreement. Yes, it assists in maintaining the utmost confidentiality between the parties by legally binding them through various clauses constituted under the non-disclosure agreement. So there is a legal binding to all the parties who are signatories of that particular non-disclosure agreement. Hence, it has importance. Hence, you should sign this non-disclosure agreement in various scenarios, which I have mentioned to you earlier, before you start discussion with any other possibility. For example, in case of sponsored research, licensing, etc. The receiving party is then prohibited from disclosing the confidential information. There are various clauses of the non-disclosure agreement also specify the time frame within which the party is required to keep the information secret. And this period could extend beyond the NDA's effective period. That means in the agreement, you can mention that the effective period is the term of that particular NDA. From the date of last signature, the term will be calculated. Generally, the term of the non-disclosure agreement is 1 year or 2 years. But after that also, the recipient need to keep the information secret for further period of say 5 years. So you can mention all these things in the clauses of NDA. Then by protecting their confidential information, businesses can maintain a competitive edge, build trust with the partners and customers, and attract investors to help them grow and expand. So these are the advantages of non-disclosure agreement. Now, let us see what all the types of NDA. That is one-way NDA. That means a party agrees to accept or disclose the confidential information. Yes. Sorry. Sorry, I'll just reshare my screen. Yes. So if any professor wishes to share the novel process for preparing a chemical molecule with a pharmaceutical company in order to check possibility of research collaboration. So this is one example of one-way CDA or NDA. That means if the processor who is an inventor, who is a proprietor of a particular process, the novel process of preparing a new chemical entity, then in that case, he should sign the NDA with the pharmaceutical company because he want to start discussion with the company for further collaboration. It may be a kind of sponsored research agreement or collaboration agreement as well. Employment contract is the best example of one-way CDA or one-way NDA, wherein only employee signs this agreement with the employer, and the employer has the confidential information which he want to protect by signing this NDA with all his employees. Two-way CDA, when two or more parties mutually agree to share their respective confidential information with each other. Both the parties have their respective confidential information with them, and both the parties are sharing the respective confidential information through one NDA, through one agreement with each other. So that is called as mutual NDA or two-way CDA, NDA, etc. For example, one company is merging or acquiring another company. So mutual NDA ensures none of the parties participating in the process divulge confidential information. So this is the example of two-way NDA. Now, the elements of NDA, what all clauses are included in non-disclosure agreement? First and foremost thing is we have to identify the parties. For example, ABC Private Limited and XYZ Institute as well. So first and foremost thing is we have to identify the parties. It can be multiple parties as well, more than two parties. But these are very rare NDAs. Generally, two parties are there who wish to sign NDA with each other. First thing is you need to identify the party. You need to write their name, address properly. Second thing is you have to define the purpose. For what purpose you are sharing this information with the other party? Whether you want to explore further research collaboration, whether the company is seeking for the investment, whether it is a employee-employer relationship. So these purposes you have to mention in the second clause, that is the purpose. And why it is important to write the purpose, because you can make sure that whatever the purpose you have written in the non-disclosure agreement, the confidential information should not be used beyond that purpose. It should be used only for that purpose. Yeah. Then third clause should be related to unilateral or mutual. That means whether it is one-way CDA or two-way CDA. So based on that, you can define. In the definition part, you have to define the definition of confidential information. What exactly the information which one party is going or both the parties are going to share with the other party. So please define the confidential information in the non-disclosure agreement. This is very, very important. Second thing you need to define is who is the provider and who is the recipient. Suppose ABC company is the recipient. So in that case, you need to define hereinafter this ABC Private Limited is called as recipient and XYZ Institute is called as a provider. So likewise, you have to define the terms. Then what all the obligations? Obligations, obviously, in case of one-way CDA, obligations for the recipient is first and foremost thing is to keep the information secret. That is the obvious obligation for the recipient, that he has to keep the information as a secret. He should not disclose that information to third party, and he need to disclose that information to its employees or the consultant only need to know basis. There is a very need to suppose the company has 100 employees. It is not necessary to each and every employee should know the NDA or the confidential information mentioned in that particular NDA. Only 2 or 3 employees who are actually going to work on this particular confidential information. For those, this information or about this agreement that the information is needed. So only on need to know basis, the company or the employer should disclose this information to their employees. There are some permitted exceptions as well. I have another slide wherein I will talk about this. Yes, return of information. Once the term of the agreement is over, you have to return all the information to the provider, or you have to destroy that particular information as per the provider's instructions. Then ownership related to IP rights, license, assignment, no ownership is there. Ownership resides with the provider only. Recipient does not have any license, any IP rights over the confidential information. You have to define the term as well. Yes, you should avoid the perpetuity. In case of NDAs, you should mention the term. Generally, the term of the NDA is 6 months, 8 months, 1 year, 2 year, maximum up to 3 years. And miscellaneous or other legal provisions such as some boilerplate clauses are there, like the governing law or jurisdiction. Then in case of disputes or material breach, what will be the structure? So all these clauses will define, should be mentioned in the non-disclosure agreement. So let us see the the definition of confidential information. A very broad definition of confidential information is mentioned over here. I have taken this particular paragraph from one of the template of this NDA, but this is very, very broad. You can narrow it down as per your convenience, or you can keep it as it is, but it is always advisable to write the specific confidential information what you want to share with the recipient. So it has all the things. For example, it is the non-technical and technical information related to the product, technology, processes, trade secret, all IP related information, inventions, improvements, modifications, discoveries, whether patentable or not, patent applications, copyrights, trade secrets, clinical development plan, material, processes, apparatus. So it has very, very broad scope. Then, yes, the permitted exceptions. Though there are the types of the information which do not need to keep the confidential. All rights have certain exceptions because there are certain exceptions to this confidential information. Now let us see what all those exceptions. So when the information is in the public domain, it cannot be considered as a confidential information. So the recipient, the obligation is not there for the recipient to keep that particular information which is already there in the public domain to keep as a secret. Then second thing is that when the recipient receives the information from a third party, if the recipient receives the information from a third party and the third party does not have any particular agreement with the first party or the provider, so in that case, these confidentiality obligations does not work. Third case is when it is required by law, regulations, rules, act, or the order of any governmental authority or agency to be disclosed. So in that cases, the recipient has to disclose the information to the government authorities. And the last point is the information is known to the recipient before signing the non-disclosure agreement. So in those cases, these are permitted exceptions, and those things we have to include while drafting the non-disclosure agreement. Yes, so disclaimer of warranty clause. This is also an important clause of the non-disclosure agreement. Like the NDA should explicitly state that the parties are not making any representations or warranties with respect to the confidential information shared with the recipient. Because the information is on as-is basis. So there is no warranty whether this information will work as per your requirement. So this particular warranty is also important. And remedy for the material breach, like the NDA should allow, in the event of breach, the affected party to be able to seek equitable relief by way of injunction. So these things you should definitely mention in the non-disclosure agreement. And if you are signing any non-disclosure agreement draft sent by any other party, then you should check all these clauses very, very thoroughly. So what are the best practices? So when the number of NDAs start reaching into the hundreds, then reviewing, negotiating, and concluding the unique contracts manually is very, very hard, and it is time consuming as well. So a standard and adaptable confidentiality agreement template you can create with the help of expert and keep it as a draft with you. And whenever you wish to share any confidential information with the recipient, in that case, please use that particular draft so that it will save your time and energy as well. Then use clear and concise language that focuses only on the disclosure. One must ensure that all confidential information shared or will be shared with the others, with the other party is clearly and unambiguously mentioned mentioned in the non-disclosure agreement. Then none of the clauses in the same non-disclosure agreement shall be confusing or conflicting with each other. Please read the clauses thoroughly and repetitively, and so that and make sure that those clauses are not conflicting with each other. Then following definition of the confidential information can be used. This is not recommended per se, but it can be used. Like the data and information that a party wishes to have deemed confidentiality, it should be it should be treated as provided. One, if in a tangible format, it should be labeled or marked as confidential or proprietary. If you are sharing any confidential information and in a tangible format, for example, on a piece of paper or any pen drive, etc. If any tangible format is there, please mark it as a confidential or the proprietary information. And if not in a tangible format, then such oral or visual disclosure, then it is identified as confidential information at the time of disclosure, and that identification is confirmed in the writing within 20 days after the disclosure. So these things are very, very important. Now we'll move on to the material transfer agreement, MTA. As the name suggests, it deals with the transfer of material. So NDA deals with the transfer of confidential information. However, this MTA deals with the transfer of biological material in any tangible form. The material transfer agreement is a contract governing the transfer of materials between two parties, and it defines the rights of the provider and the recipient with respect to the materials and any derivatives. It also defines what is being shared, for what purpose, and how it can be used. So MTAs ensure that the transfer of biological samples and associated data is conducted transparently and efficiently while protecting the interest of the sample owner or the material provider. In order to protect the interest of the material provider, these material transfer agreements have been generally signed. The materials may include cell lines, plasmids, nucleotides, proteins, transgenic animals, plant varieties, bacteria, pharmaceuticals, any chemical reagents, etc. So the agreement address the issues such as ownership of the transferred material, modifications, and derivatives made by the recipient. So material transfer agreement avoids the duplication of work. You can share the resources, whatever you have with you, with the another institution, and which will avoid the duplication of work. Then there are various types of entities are there. So public research entities which are focused on advancing the knowledge, they are more open to share the material than the commercial entities. So there are some hurdles as well for this material transfer agreement. The nature of material is very, very important. So research tools and biosamples are shared more freely, while final products are less likely to be exchanged between with the help of this material transfer agreement. Yes, market dynamics, competitive industries, for example, pharmaceuticals are more focused on the market potential of the innovations, while academic institutions prioritize gaining funding and prestige. So these things really matter while drafting this material transfer agreement. Now, why do you need this material transfer agreement? Like to prevent the misuse of the material transfer to the other party. So what does it mean? The misuse of the material. Suppose if I have developed the genetically modified organism for a specific purpose, and then that is a proprietary biological material with me. And if I want to derive other applications of that particular organism, in that case, I have to share that material with the third party, wherein I can sign this material transfer agreement. Now, what all things may happen over here? Like if I have shared the material with the third party may claim that that material is the ownership of that material resides with that third party. They can also file a patent depending upon the application on their own name. And they can also publish the results, whatever they are going to conduct with that particular material. So I'm not getting anything out of it, though I have invested my time, money, and intellectual inputs in developing that particular genetically modified organism. So in order to protect the owner's interest, in order to protect the provider's interest, these MTAs are usually signed. So it is to get the proper compensation for your intellectual efforts, to protect the interest of the provider, and a public health emergency can depend upon the ability to move relevant samples and associated data from one place to another. In case of public emergency, MTAs are very, very important. Then it enables the transfer and subsequent use by the recipient while it's protecting the interest of the transferee. And intellectual property, who owns the improvement, who owns the new applications, who owns the patents, etc. So all these things are very, very important in case of material transfer agreement. And MTAs reduce legal risk and disputes by ensuring that materials are used as agreed. Now, when to use the MTAs? export or international movement of the samples and associated data. In case of export, if you want to export the material, then domestic movement of samples and associated data to a separate legal entity. Then determining the eventual use or further distribution of samples and associated data shared for one purpose, but with potential for additional uses. Then uses or purposes where there are specific rules or regulations, or when a third party such as government agency is involved. Then where the material being moved as a potentially important intrinsic value, either the material itself or the possibility of using it in other processes or for product development, and as a part of large overarching agreements such as research protocol or bilateral agreement. So in all these scenarios, you should the MTAs are very, very useful. Yes, incoming MTA and outgoing MTA, as the name suggests, incoming MTA is when you are receiving the material from another party, and outgoing MTA is when you are giving the material to another party. The transfer between, it can be a transfer between academic institution or research institution, or it can be a transfer between academic institution or industry, or it can be a transfer wherein industry has the biological material and they want to give it to the academia for further research. So these can be, so depending upon that, the MTA can be drafted. But the general clauses of the MTAs comprises of, first thing is definition. As we have seen in case of NDAs, it is very, very important to define the confidential information. Likewise, in case of MTAs, it is very, very important to define the material. So what exactly the material which is going to be shared with the other parties. Then provider, recipient, etc. So all these information, the definitions are very, very essential. Restrictions of recipient use of material. So this clause is also very, very important, like not use on humans, recipient's responsibility of safety and handling precautions, and any activity will be conducted as per the applicable laws and regulations, else will obtain permits and approvals. So recipient should use the transferred biological material very, very carefully. He is not allowed to use it on or the treatment of human beings. It is a responsibility of the recipient to for the safety and handling to follow the safety and handling precautions. The provider has to provide all this information along with the material to the recipient, okay, related to the safety and handling or any other protocol, specific protocols are there. Then the recipient has to ensure that he is conducting the research or he is conducting the experiment as per the applicable laws and regulations, and if not, then he has to obtain any permissions and approval. So the burden of getting these approvals and all other things lies with the recipient in case of MTAs. Then what all the providers right? So publication and IP, provider is the owner of the material transfer agreement. So the publication rights generally resides with the provider. Whatever the results we as a part of this research program or the project plan between the two parties, whatever the results are generated, so those results are the property of the provider. But in some cases, the recipient can also publish the results by by duly acknowledging the provider. These type of clauses can also be written. Then IP, either the IP vest with the provider or the IP vest jointly with the provider and recipient. So these things are generally common for the provider's rights. Then no commercial rights. In case of MTAs as well as MDAs, no financial arrangements are involved. When you are transferring any biological material, generally the material is transferred, biological material is transferred with no commercial right, no financial arrangements are involved, and it is no commercial rights in the sense you are allowed, the recipient is allowed to use the particular material only for the research purpose. He should not sell, distribute, offer for sale, or use it for a commercial purpose. Then no further transfer of rights without explicit permission of provider. Suppose I am the recipient and I am giving it to my friend for the further research. That is not at all allowed. I have to take permission from the provider. Then modification of material, if the recipient intend to modify the material, that you need to negotiate beforehand, before drafting this MTA with the provider. And what are other applications or any details that you want to develop further. So all those things should be particularly jot down in the project plan or the research work. And that project plan or the research work can be added as an annexure or the appendix to the main agreement. Then publication right, recipient can publish data for the experiments which he carried out while duly acknowledging the provider and source of material. Informing about toxicity, health risks, etc. to be informed by the provider. Term, yes, you have to define the term, specific term of the agreement or the termination by either party. Then confidentiality, the confidentiality clause should also be there in the MTA, that both the parties need to maintain the confidentiality of oral and written disclosure with respect to the biological material. Yes, the termination, the use of material shall be discontinued if any of the party breach this particular agreement. In that case, in case of termination, the material shall be returned or destroyed, returned to the provider or destroyed with the instructions from the provider. Yes, I have already talked about this ownership of IP rights. Then warranties. Like in case of the NDAs, we have seen that no warranties are there from the provider. Here also no warranties are there from the material provider. Material is provided on as-is basis. No warranties. No warranties of merchantability or fitness for a particular purpose, or that the use of the human material will not infringe any IPR. So whether this material is infringing any other intellectual property, for example, patent, so there is no warranty. The recipient has to check, recipient has to do the due diligence thoroughly. Liabilities, assignment, amendments, notices, and dispute resolution. So these are some boilerplate clauses. So those things shall be included while drafting the MTA. No reverse engineering is allowed. That means the recipient agrees that it will not attempt to analyze or otherwise reverse engineer the material. Now, there are some limits of MTAs, like dependence on the agreement, like MTAs rely on mutual agreement and which can be hindered by conflicting priorities. For example, in case of research institution, their priority is getting grants and taking technology, for the scientific progress, etc. But in case of the legal team or any industry, their asset is focused on their focus lies with the asset protection. So it is very, in those cases, they may not want to sign the MTA. Then implementation challenges, that delays in the negotiation and transfer of material. When you draft the MTA and give it to the other party, the other party will definitely come back with their suggestions and they want to negotiate these things with you. So there is implementation challenges as well, and it is time consuming. Then transaction costs, the lengthy negotiation process and cost associated with legal team involvement and misunderstandings between departments can slow down the research progress. Inconsistent terms are also there. The lack of standardization in key terms and leads to the confusion and increased legal disputes as well. So the standardization is a solution for all these things, for all these limitations. Like the lack of commercial customs and standardized practices in the biotechnology complicates the MTA negotiations. So what exactly is the solution provided by Autumn, that is UBMTA as a model. So there are standardized agreements available, such as Uniform Biological Material Transfer Agreements. So these can help to reduce the transaction cost, streamline negotiations, and improve the collaboration across the institutions. So these are some standardized agreements. So Mamatha is going to talk about this UBMTA. So these are the questions to be asked before drafting the MTA or before signing any material transfer agreement. Whether the recipient is a for-profit company or whether it is a academic organization, research entity, Then is the material human derived, genetically modified or hazardous? Does the material require special protocols of handling? Do I want anything in exchange for the material other than the shipping cost? Generally, the shipping cost is only included in the material transfer agreement. But apart from that, do I want anything else that I need to ask? Then is any component of the material proprietary, and do I want it to keep confidential? In that case, you can also sign the NDA along with MTA. Am I preparing my own publication relating to the material? Then could the results of recipient's research be commercialized? Is any component of the material potentially patentable? Then is any component of the material owned by a third party, or is the material currently licensed? So the best practices is the MTA or similar agreement should be executed to document the obligations and responsibilities of the parties involved in the transfer of materials from a repository prior to the shipment. The agreement should be in place before the transfer occurs. It is always advisable to sign material transfer agreement whenever there is a chances of transaction of the biological material, tangible biological material. Repositories that receive or send material should have an MTA and maintain the documentation of such transactions. Repositories should have templates of this document that can be used or modified as needed. The project plan and transferred material can be separately mentioned in the annexure approved with the signature or the signature of all of the parties. So the experimental plan, what exactly you want to do as a research with the help of that biological material, that you need to mention that what is the scope, then background, what exactly the problem you are solving, and how the research is planned for a further period of 1 year or 2 year. So all these things you have to mention in the annexure as a project plan. Then explain the material very clearly, the title, description, list of material, protocol of handling, the toxicity details and amount of the material, etc. So please mention all these things very, very clearly in the MTA. So these are some templates of MTA. So what I will do, I will just show you. This is one research confidentiality agreement. So here the name of the parties are mentioned. Then here the purpose is mentioned, where the university is willing to disclose certain non-public confidential information, whether overall written, etc. So I hope it is visible to you. Then the recipient shall treat the confidential information in the strict confidence. The recipient will not make use of confidential information except for the purpose. Then recipient obligation as expressed in section shall not apply to any information known to recipient. So all these clauses which I have discussed are there. Yes. So generally MDAs or NTAs are very short, maybe five or six pages document. This is MTA. The parties' names along with their address is mentioned, and upon request for a specific quantity of material by the recipient, such material shall be provided by the university to the recipient, subject to availability of such material. And the availability of such material shall be determined by university. So here the IP rights, the reverse engineering, no warranties, then what exactly the material is shared, all these things have been mentioned. The term of the agreement also is mentioned. So these are typical drafts of NDA and MTA which I want to share with you. So I'm done with it. Now Mamta will take over. She will talk about UBMTA and one case study. Thank you. If you have any questions, we will discuss it later on once Mamta finishes with her presentation. Yeah. Hello? Hello? Can you hear me?
Yeah, we can hear you, Mamatha, and we can see your screen also.
Okay, thank you. With the broad introduction given by Archana, now I'm going to be talking only specifically to the biological material. So this standardized format is the Uniform Biological Material Transfer Agreement. In short form, it is called as UBMTA. So let us see what is the meaning of UBMTA. It is a standardized legal framework, and it is created just to simplify and expedite the transfer of biological material between the academic, non-profit, and other research institutions as specified by Archana. And it also eliminates the need for repeatedly drafting and negotiating the individual material transfer agreements. So we did not have to invest a lot of time in order to draft these agreements and then proceed every time. So we have this gives a UBMTA gives us a standardized legal format wherein all the clauses are mentioned and what are the things that we are going to exchange, and this is the standard format that has been given. We need to fill the gap in it. Sorry, one second.
Yes, Mamatha, you can.
Yeah, one second.
You can go ahead. Yeah. We can see the screen.
Okay. Now there are there were various challenges which had occurred before starting with the making of this UBMTA. Like there were why it was needed. Like we already had MTA in hand, but why did we need? Why? What was the need for us to have the UBMTA? There were various complex and restrictive MTAs imposed, and these actually restrictions and the complex restrictions that were imposed by these, which were written in these MTAs, actually impose significant delays in sharing the critical research material. And there may be some legal problems that might have occurred because of these reasons. The people couldn't share the material with the recipients could not receive the material in time. So the research was actually was hampered. And in addition to that, the researchers often encountered administrative hurdles when obtaining these materials from other institutions. So in addition to that, when there was a collaboration between two institutes or between a university or between some other research institute, there was a need for a legal framework that encouraged open and timely exchanges, because of those things, the research could be, and the productivity and the innovation could be carried out in a streamlined way. And in addition to that, they wanted to simplify the administrative hurdles that were happening. So that means that they wanted to reduce the burden on the technology transfer officers and also allow the researcher to focus on their work. And these were the main reasons why this UBMTA was designed. So let us see why what was the historical background for obtaining this, for starting with this UBMTA. There was a growth of the biotechnology and academic research partnership during 1980s, which actually revealed there were a lot of inefficiencies in sharing the biological materials. And these master MTAs, which defined the terms of the material exchanges, were overly specific and time consuming and often delaying the important research. There may be some of the MTOs clearly said that when they were giving the material to the recipient, they actually had made some clauses which was very difficult for the recipient to continue. For example, in case of a tissue culture plant, when the donor might have given the material to the recipient, and he might have specified the cultural conditions under which these plant has to be grown, but those conditions might not be available with the recipient. At that time, there was some problem. The recipient could not continue the research for in order to conduct they couldn't conduct the experiments which was very much needed for his research work. So this was one of the example. There might be other problems that might have been encountered with the recipients when the donor was giving, when the donor had restricted or put the several clauses in the MTAs. In addition to this, the faculty, there was a lot of burden on the administration. Like the faculty, researchers, and TTOs spent considerable time negotiating the terms and resolving disputes over the material usage, ownership, and the intellectual property rights. All these things were taken up by the Archana. Now, in this case, the NIH, which is the long form is National Institute of Health, actually initiated the dialogue with Association of University of Technology of Managers and other stakeholders in the year 1990. As a result, NIH brought importance of, or they actually brought out the need for a universal agreement to expedite the research collaborations and eliminate the bottlenecks, which were actually created by the traditional MTAs. So NIH actually took the initiation to solve this problem. So outcome was that when the collaboration happened, this led to the creation of UBMTA, that is the Universal Biological Material Transfer Agreement, with a focus. The main objective of this creating this UBMTA was to fostering open non-profit research collaboration. And the goals of the collaboration was to simplify the transfer process, especially between the non-profit institutes, and to address the concerns about the proprietary rights to facilitate the smoother transfers between the for-profit and non-profit organization, and to create a legal framework that balances the accessibility with the protection of the intellectual property. These were the goals which were mainly covered during the collaboration between the NIH and AUTMs, which led to the creation of the UBMTA. And as a result of this collaboration, the main milestone that was obtained was published in the Federal Register on March 18 as a standard framework, and it established as the preferred method for non-profit institutes to exchange the research material. Now, there were various problems that were encountered during the biological material transfers. These may be like the definitional challenges, like the terms were not defined properly. For example, in this case, the precise definitions were critical. That means if you are not defining these terms or the terms or properly in the MTA, then it might create a problem in the later stages. So these key terms has to be defined properly. For example, original material. What do you mean by saying original material? It is the material that is provided by the donor. And the progeny term can be defined as a material grown from the original. That is, you are obtaining this material from the donor. And the unmodified derivatives, that is, these are the components derived without the alteration from the original material. And the modifications are the altered or combined substances. These may be like the person who has received the material might have done so many experiments, or they might have done the transformation studies. He might have transformed the material, which comes under the word modification. That means it has been original materials has been altered by the recipient. So that comes under the modifications. Now it also defines the ownership and the control. The UBMTA also clarified the ownership rights to the ownership rights. Though the provider rights includes the provider shall retain the ownership of the original material, any progeny, and the unmodified derivatives. That means unmodified derivatives. But on the other hand, if the recipient retains the rights on or he owns the substances they create, but only if they do not include or depend on the provider's original material. That means if he has done the transformation, only those plants which are transformed from the original material are only on those plants these recipients are found to have the rights. But the original material and other related its progeny and unmodified derivatives of the original material will be over. Those rights are given only to the provider. And in addition, if the recipients, if he wants to file a patent, then resulting from these inventions, then he has to give acknowledgement to the provider. and he has to notify the provider initially, and then he has to notify the provider regarding whatever the modifications that he has done and whatever the methods that has been involved during using those original material. And he also acknowledges the provider regarding the in the patent, depending upon whatever the clauses that have been agreed between the party one, I mean donor as well as the recipient. Now, what these are the Archana has already taken it up. Like the materials that are used as a biological materials may be cell lines, DNA, and the molecular components like the proteins, pharmaceuticals, and antibodies, etc. And these materials may be protected by the patents, trade secrets, privacy laws, and the rights. And these protections may affect the UBMTAs. So this has to be mentioned whether these things have been already patented or it may be it has under the trade secrets, etc. So now let us come to the implementation of UBMTA. So this UBMTA, there were the people were it has to be adopted and published and it has to be published alongside a detailed implementing letter. So they have designed an implementation letter which actually helps the institutions in adopting the framework. So it was so perfect and it was so useful that by the mid-1990s, more than 300 institutes had already signed the agreements to follow these UBMTA principles. So though they had more than 300 institutes had already registered, there were some challenges which were encountered during the adoption of these UBMTA. So these are considered to be the non-profit institutions often prefer negotiating individual agreements to address the specific concerns bypassing the standardized framework. They wanted some more stringent points to be included in this MTA. So they did not agree with the standard by UBMTA that was designed by the NIH as well as AUTM. And in some cases, case-by-case reviews were also happened. So many transfers required tailored terms, particularly for the sensitive or high-value materials. So these people did not agree. These people did not agree with whatever the clauses that were mentioned in the UBMTA. And in addition to that, for-profit institutions did not agree and they were reluctant to use the UBMTA due to the fears of intellectual property laws and also concerns over the material misuse. They thought that the material may be misused and the intellectual property may be claimed by the recipient. So they were not ready to accept this UBMTA. So in addition to that, there are some challenges which are still going on, which we can deal with this ongoing challenges. So these are the complexity. First one is the complexity, and even with the standard framework, material transfer often involve detailed negotiations to address the specific scenarios. And the commercial interest for-profit institutions impose the additional restrictions to safeguard their investments and proprietary technologies. And in addition to that, inconsistent adoption includes the non-profit institutions frequently modifying the terms of UBMTA agreements, undermining its uniformity. So these challenges are still going on in order against the UBMTA. So how we can overcome these challenges, which by doing, we can do that by promoting the broader use. Like we can encourage the institutions to adopt UBMTA for the common material transfer, reserving the custom agreement. So you can have the custom agreements for the exceptional cases. For example, it may be high costly materials or specific materials, or it may be a sensitive material. And we can simplify the process, like they develop a shorter and the lesser restrictive agreements for routine transfer. And we can also embrace the digital tools to automate the preparation, signing, and tracking of MTAs. This actually reduces the delays as well as the administrative workload. So by doing all these things, we can overcome the challenges that we are still facing. So now recently their initiatives have been taken in order to for the improvement of this UBMTA. So these are the Science Commons, Adgene, and EMTA Commons. So in case of the Science Commons, it mainly aims to create modular standardized contracts to address the diverse material transfers, which may include the UBMTA as a fundamental agreement, simple letter agreements for straightforward transfers, and the alternative clauses for specialized agreement requirements. And the Adgene is a non-profit plasmid repository using UBMTA for the most transactions. And we can have a case study in the later part. And in this case, it operates on a web-based system that simplifies the request as well as the agreement process, ensuring the faster transfer and the better record keeping. And EMTA is the digital platform which is developed, which involves the multiple research institutions with the key features like the custom workflows to accommodate the institutional policies, searchable database, and the standardized agreements for the efficient processing. So in conclusion, what we can come out of this, we can say that the significance of UBMTA may include that it actually simplifies the material transfers, it reduces the delays as well as it enables the collaborations. And as a result, the research can happen easily. And in addition, it promotes the trust and the standardization among the participating institutes, and it can streamline the process of sharing the biological materials, which actually enables the faster and research collaborations. In addition, it also fosters the trust and transparency by providing clean guidelines on the ownership, usage, and the intellectual property rights. So what we can have in the vision in the future is that the universal standardization and the digital integration as well as the collaborative research center. It is like first one is in case of the universal standardization, widespread adoption of the standardized agreements can be considered. In case of the digital integration, advanced web-based platforms can be used for the MTA processes, which can automate the processes and which actually increases the speed as well as the accuracy. And the collaborative research culture may help the reduce the administrative barriers, and the research community can focus on the innovation. Okay, leading to foster scientific breakthroughs and the transformative discoveries. So these are the definitions, terms which are defined in the UBMTA. So this is the provider, who is the provider, who is the provider scientist, who is the recipient scientist, who is the original, what is the original material, what is only material means, what is the progeny, and what is the unmodified derivatives, modification, commercial purposes. And these terms are clearly defined in UBMTA. So now let us see, in case of the CRISPR and Adgene research, it is one of the case wherein the adopting the UBMTA has actually increased, or it has fastened the research that was happening in the CRISPR technology. So CRISPR is a groundbreaking tool for precise and the safe genome editing in living organisms, and it is considered to be the significant potential to transfer genetic research and the application. So what is the role of the Adgene here? It is a non-profit organization which was established to accelerate the science, and it facilitates the open distribution for the CRISPR reagents, RNA, and plasmids for the academic use. And in addition to that, it also promotes the access to the materials and information for the researchers globally. So how do we do how this is working? So in the first step, you have to deposit the agreement. It is to be initiated. The step one can be initiated by depositing the scientist technology transfer office, and then the deposit agreement can be signed, granting Adgene to be as an authority to distribute the material. So here the Adgene is acting as a mediator, wherein he is receiving the material from the donor and it is transferring it to the recipient with some terms and conditions which both the parties are agreeing here. In case of the step 2, the material transfer agreement has to be written. In this case, it actually requests a scientist and or a TTO to complete the technology transfer officers to complete the material transfer agreement. And in addition to that, the process can be streamlined by using the electronic MTA, that is EMTA system. And how the efficiency MTA is also found to be very important here, because average turnover, because since it is done electronically, means it is done online, the average turnover time is found to be 2 days. And one signature from the research requesting scientist or the TTO can enable the execution of the thousands of MTOs quickly and efficiently. So you can imagine, like, if it is happening at that rate, then how the research work can be taken ahead in a faster rate. So in addition to that, it also maintains the documentation and the record keeping. It maintains the detail, Adgene actually maintains the detailed transaction records, and it actually gives the online access provided for both the depositors as well as the TTOs, and it enables the precise tracking of the distributed materials and enhancing the accountability. This gives the enhancement in the accountability. So everything is documented and accountable. So as a result, we can see the achievements of the Adgene. The impact of the sale is to 2 lakh MTOs was facilitated to date, that is up to 2020. And current distribution rate is 600 items per day. And the researcher in 95 plus countries benefit from the Adgene's resources. So this exponential growth in the CRISPR can be seen in this case. So as a result, we can see the benefits of this Adgene's approach, like Adgene's approach of adapting the UBMTA. So it helps in facilitating the collaboration as well as it has helped in the streamlining the workflow. This results in the encouragement of the global scientific cooperation and also the accurate record keeping, which is found to enhance the transparency as well as the trust. So, but there are some certain challenges as well as limitations with respect to the Adgene. These are not all the CRISPR constructs are accessible through the Adgene. So that is also very important because most of the CRISPR constraints are not deposited with the Adgene. So if all of them deposited, most of them will deposit to the CRISPR constructs to the Adgene, then it can be the research, it can be transferred to the recipients and the research can go on. And next one is navigating the commercial interest. The academic and the commercial interest sometimes clash, particularly for transformative technology. So as you have seen, like there may be some clashes between the recipient's interest as well as the donor's interest. And in addition to that, the commercial potential can also hinder the open sharing of the materials for the academic research. So we can say that if we overcome these two parts or like availability with all of them, if the maximum number of the CRISPR constructs are deposited, as well as if we have an agreement, like if we come to one common point wherein the commercial as well as the academic interest can be met. If we overcome these 2 points, then the using of UBMTA can increase the rate of the research that is happening today. Thus, we can conclude that the Adgene has revolutionized the distribution of CRISPR materials supporting the research worldwide. Its success highlights the importance of the efficient processes, and moving forward, balancing academic collaboration with the commercial incentives will be crucial to sustaining innovation. So the same thing is happening in case of the BioBricks Foundation, wherein the 3 collaborative work has been happening here. In this case, the BioBrick Public Agreement has done the framework for sharing the engineered biological sequences. And in the case, Open Material Transfer Agreement actually simplifies the as well as standardize the sharing of the biological materials, which actually promote the broad sharing without restrictions. And the development, it also helps in the development of the collaborative effort led by the Big Big Foundation as well as the Open Plant Scientific Biology Research Center. And these two, along with the IGM Foundation, actually works in collaboration with one another. The IGEM Foundation is the registry. It actually is a primary research for over 20,000 biological parts, which are growing annually. And it also has it has the depository for the DNA sequences related to the information available online, and it can be accessible at this website. And it actually concerned with the distribution practices, like it helps in the sharing of the biological parts with the academic laboratories upon request, and no MTA is required for sharing parts, including those used in the student competitions. That is very important. And the technical standards are biological parts must be compatible with the BioBrick RFC 10 assembly standards. So some standards have been designed in this case, and these biological materials should meet those standards. And it also helps in the easy combination of the parts for the research and applications. So this collaboration of these three actually has led to the open and collaborative innovation, and it is mainly responsible for the research practices in the synthetic biology. So this collaboration of these three organizations actually has enhanced the accessibility to the accessibility to the biomaterials as well as the legal frameworks. And in addition to that, there is a drive progress in the synthetic biology through community-driven initiatives. So this is a UBMTA implementation letter. So it has the which is the organization, which is the authorization official as well as the signature, and this is the format which has to be which format for the implementation letter. And then comes the format of the UBMTA letter, which actually you have to fill in these details. This is a standardized one, and wherein you have to give the provider details, recipient fee details, as well as the original material, as well as the termination, like the duration of which time period you want to have this UBMTA agreement. And in addition to that, what is the transmittal fees. In addition to this, it also has the who is the provider scientist, the details of it, and as well as the recipient scientist and the details along with the signature. And this, in addition to that, the recipient organization certification is also involved, wherein it is going to certify that the recipient organization has accepted as well as signed the unmodified copy of the UBMTA. So these are the details which recipient organization has to fill in. So that's all, like these are the formats, these are the standardized formats that can be used by any of the organizations, or it may be by the recipient or from the donor, which actually helps in keeping the research going on. So that's all from my side.
Thanks, Mamatha. Before you take questions from the chat box, Archana and Mamatha, let me just alert the participants. The feedback link is there in the chat box. Please do not leave the session without filling up the feedback link, because it's very important for us to plan further sessions as per your inputs. Thank you. Yeah, over to you, Archana and Mamatha.
Yeah, so I can see one question over here. So let me read this. Does NDA need to be stamped, or is the NDA valid if taken in the institution's letterhead? Actually, NDA is governed by the Indian Contract Act, and it is a legally binding document as well. So it is recommended to get the agreement on the stamp paper to ensure the validity and enforceability. But it is not required to get it printed on the stamp paper. You can print it on the company letterhead as well. But the witness's signature is very, very important because in case of there is a limitation period, the period called as a limitation period of 12 years in case when the witnesses have been signed on the agreement. And otherwise, without witnesses, the limitation period is 6 years. So limitation period is that means it is a legally specified period after which no legal action can be brought in the court of law. So the witnesses' signatures are very important, and the stamp paper as well. The stamp duty is varies as per the states, different states in India. So depending on that, you have to purchase a particular stamp paper and get the print of the India on it. Second thing is related to second question is related to when applying for government grants, how to protect our idea provisional patent with NDA. Our proposals are reviewed by external invigilators who have access to sensitive data of our technology, and that we have to disclose in the application form. See, as far as the government grants, etc., are concerned, I don't think there is any NDA per se is there. So you can disclose, you have to fill up the application form, you have to pitch related to your technology. You can disclose the non-confidential features as far as it is possible. But during the screening process and while pitching, if they ask you the specific questions, then you have to at least orally disclose your technology to the to the reviewers. Uh, but in case of government grants, etc., there is no NDA available from their side. You can ask for them in some cases if it is available, if they have any format ready with them, and if it is not, then you have to do or you have to present your information as it is without NDA. So there is no remedy for it. Yes, you can do one thing, that you can file the provisional specification if the technology is very, very proprietary in nature, and then apply for the government grant, because then it will secure the filing date, and then you are free to disclose your information.
Sorry to interrupt. NDA is not available when they are going to give grant to us, but only when the grant is given to you. And that time there is an NDA saying that everything that has the research that you have carried out using that grant, it has to be, you have to acknowledge that particular funding agency, and you are going to it is a property of that funding agency or the institute where you are working. That agreement you will have to sign after the fund is granted to you.
Oh, okay. So third
In the
question is,
beginning, there is no agreement, like NDA is not there when before granting of when we go for the presentation.
yeah. Third question is related to, do investors generally agree to enter into India with the startups before startup pitching session? And if investors are not agreeing, what are the options left with the startup? So please prepare a standardized NDA draft. That is first and foremost thing, with the help of expert. And please share this draft with the investors before pitching. And please get it signed with them with the request. And if they refuse to sign this NDA, then you can disclose the non-confidential information, and you can tell them that we are disclosing the non-confidential information to start the discussion. And if they want any detailed information, then they can sign the NDA. So that thing you can do. Third thing is, we have also received one request, like kindly share the draft of UBMTA after this presentation. I have shared some links over here. You can download the letter agreement draft, etc. And we will also try to share these drafts with you over email. Another question is related to, is it necessary to sign NDA during regulatory submissions? See, NDA, wherever you feel that you are disclosing the confidential information to any third party, in that case it is always advisable to sign the non-disclosure agreement. But there are certain exception, and there are certain conditions as well, depending upon where you are disclosing, what is the forum. And depending upon that, you have to decide. For example, in case of government agencies, if you are disclosing the confidential information, then you don't need to sign any NDA. What else you can do is, you can file the patent in order to protect the first filing date, because then you will secure, then your invention will be secured, and then you can disclose the information. Please share both the presentations. Yeah. Another question we have received in the chat box is related to, our company startup allowed to take Adgene plasmids for research purpose? Mamta, do you
Yeah,
want to take it?
yeah. We can take it, but we need to check whether these plasmids are available in that depository. If it is there, then we can go ahead for the research purpose. But even at that point, you need to specify the purpose, as well as you need to sign the UBMTA agreement.
Yes. Yeah, another question is related to, does NDA stands valid before filing provisional patent, and will it safeguard the patent? See, patent, you don't need to safeguard. It will automatically come into the public domain. So patent will safeguard your technology by first filing date, right? Once you file the patent application at the Indian Patent Office, you will secure the first filing date, and nobody else can file the patent on similar technology afterwards. That person will not get the patent because there is no novelty. So the patent will give you because first to file system in most of the countries in the world, whoever goes first at the patent office for filing the patent, that person will get the patent. So the provisional patent will secure the first filing date of your technology, and it will automatically come into the public domain after 18 months. So you don't need to safeguard the patent. Okay. You need to safeguard your confidential information. Are there any other questions, or we can close here?
Yeah, that was all in the chat box. If anyone else have any questions, we can pass them on to you and Mamatha. So with this, we come to the end of today's session. Thank you, Archana and Mamatha, for this wonderful session on NDAs and MTAs. And let me remind everyone once again about the feedback link. Also, let me alert everyone about the upcoming talk in this talk series, which is on only competitive analysis. And our speaker is Dr. Vinod Mewani. So we will meet at 4 o'clock on 10th of December for this next talk in the only one theme. Thank you and good evening.
Thank you, everybody.
Thank you, everyone.